All right, thank you all for coming so much. I would like to hand this over to our attorney here, Zahava Schechter.
Thank you so much. And I'd like to thank, I am Zahava Schechter. I'm an attorney in New York State, 33 years. I'd like to thank the Bayville Free Library for bringing me back to speak to its members and for bringing many informative and interesting programs to your attention. So thanks again for having me, and here we go. Here is my contact information. My office is in Westbury if you need to reach me. I am certainly available by phone or by email. If you have a question now, please put it in the chat, as Christy said. Then again, there again is my contact information. So my primary areas of concentration, just to tell you very briefly about me, are real estate conveyances. That means on the residential side, houses, condos, co-ops, as well as commercial properties. I also do a lot of estate work, estate planning, and estate administration. So wills, healthcare, proxy, power of attorney, trust. And then after people die, I help the loved ones pick up the pieces, basically, and I do some business law. If you like podcasts, I have a podcast which I host called the LI Law Podcast, Everything Legal on Long Island. We just downloaded some episodes, one on the cannabis law, and one on some developments in Nassau County, and you might find that interesting if you like podcasts. So let's dive right in. The first thing I want to say about, since we're talking about real estate here on Long Island, is please be aware of the deadline for Nassau County assessment, tax grievance, and star discounts. So what does that mean? First of all, I want you to see the last bullet point on my slide. There is no separate tax grievance for the Village of Bayville, which is a very good thing. So you don't have multiple tax grievances. However, if you are not grieving whatever the assessment is for your house, I can tell you right now, you're behind the 8 ball and your neighbors are grieving and your tax burden will be higher. Why do I say that? Because there's a certain budget that goes not only for the Village of Bayville, but Nassau County in general, town of Oyster Bay, and somehow they have to find that money. And based upon all the different properties and what their values are assessed at, based on that number, the tax burden is apportioned. So if you are grieving your taxes, that's what we call it, a tax grievance. If you're grieving your taxes, your tax burden, your tax assessment can never go up just because you're appealing any amount. It can only go down. So there is no downside to applying for a grievance. Most people would tell you that you should do it because, as I said, your neighbors are all doing it. So there are some links. If you have any questions, feel free to ask, but I strongly suggest that everyone file your tax grievance. As you see, the deadline has been extended. It was March 1st, been extended to May 2nd. Please don't wait till that time to file it. I want to talk about a couple of exemptions. This is for owners of homes, although people who are buying as well need to be aware of this. If you are making capital improvements, I'm not talking about painting your walls. I'm talking about adding a bedroom or a dormer or putting a pool in, or converting maybe a garage to habitable space, something that is going to alter, as in appreciate, bring up the value of your home. If you do that, number one, you know you must get a permit and a certificate, but there is a period of time for which you could get either a reduction based on the alteration, reduction in taxes, or for solar panels, there is actually no tax increase for the first, I believe it's 10 years. There are certain alterations that the town wants to encourage you to do, and as a result, they're going to help you from a tax perspective not to feel the burden too soon. So be aware if you're doing home improvements, again, not painting, not changing out light bulbs, but doing something major to your house, this is a good exemption of which to be aware. If you are a veteran, you've served in our in any of the armed forces, there are tax exemptions to which you are available to you. I would definitely apply for these if this applies to you. The place to go to is Nassau County Department of Assessment. Cold War veterans exemption. There is an additional exemption. These are exemptions from taxes or reduction of property taxes. That's what we're talking about, available to veterans who served during the Cold War period. So be aware, in case you weren't aware before, this is something that is available. The STAR exemption program. So most of us know if you live in your home, right? Your home is your principal place of residence. You're entitled to what's called a basic STAR. There are people who have an enhanced STAR based on either age or financial needs test. However, at a minimum, if you live in your home, you're entitled to a basic STAR. If you have investment property, you cannot get the basic STAR for numerous properties, only for the one where you live. But just be aware, there are all kinds of programs out there, and make sure that you are familiar with them so that you can get the exemptions or reductions in taxes to which are available to you. And we just talked about STAR. STAR is actually a credit program through New York State Department of Taxation and Finance. Maybe you receive a check from them from one time in the year after you file your tax returns. Just be aware of all of these programs. Okay, let's get right into property. Let's talk about different types of real estate, real property, and personal property. So real property is defined as something immovable, like a house or some type of building, something attached to the land. Interestingly, condominiums are also included in this category. However, cooperative units are not included as real property. They are considered personal property, mainly because what do you get when you buy a co-op or you sell a co-op? It involves shares in a corporation, just like if you were selling or buying shares in Apple or IBM or any other corporation. So as a result, there are different rules that apply to both. I just want to say I'm right now representing purchasers of a co-op. And a lot of people think co-ops are great things to buy because usually they are less expensive. That is true. However, keep in mind, you must be approved by the co-op board and jump through a lot of hoops, and it takes quite a long time. So there is no one perfect type of purchase, whether it's real property or personal property, a condo, co-op, house, etc. There are pros and cons to everything. So keep in mind, when you're looking at a co-op, you must get the approval of the co-op board. Okay, let's go through the transaction. Oftentimes I'll sit with clients and they'll say, I don't even know what's going to happen. Can you tell me what the progression is? How do we start? What do we do? So the first thing you do if you're a purchaser is you see a property that you want to buy and you make an offer. I just want to say, as a seller, just like I write here, your choice of realtor is very important. For a seller, it's also very important because, like everything else, location, location, location. If you're choosing a realtor, I can say this because I'm a lawyer, not a realtor. If you're choosing a realtor, why wouldn't you pick someone who knows your area? Someone, if you're selling a home in Bayville or you want to purchase in Bayville, look around in the streets. What are the names on the signs? I don't know, no one's paying me to say this, but what are the names on the signs of the properties for which have been listed for sale? You know, chances are, if you see the same name over and over, or a couple of names over and over again, probably that person or those people, those brokerage houses, are very familiar with your area, with Bayville or with any other area, and therefore they can represent you and your property a little bit better. Okay. The purchaser's offer is then accepted by the seller. Now, does it have to be accepted? No, it can be rejected. You as a seller want a certain amount of money. The purchaser offers a certain amount. The seller can say, no, I want more. I want different. I want more down payment, more, less mortgage. I want all cash. We'll talk about these things, but just know the seller does not have to accept any offer. So what's happening in the market now? We're going to talk about this as we go through. Right now, there aren't a lot of houses, what they call inventory, not a lot of houses available. And so many purchasers are offering very high sums for the limited amount of houses available. Most houses are selling for at least listing price. That means how much the seller is originally asking for, if not more. right? The problem here, I just want to say for purchasers is, as I'm sure you know, if you read Newsday, the interest rate is rising, the mortgage interest rate. So if you don't get a property soon, the rate is going to continue to go up, which means that your monthly, as a purchaser, your monthly interest rate, your monthly premium payment is going to be higher. Interest and principal is going to be higher just because the rate is higher. So for sellers, it's still a good market. However, for sellers, be aware that purchasers' buying power is being impacted by the rising mortgage rates. So I don't have a crystal ball. I don't work for the Federal Reserve Board, but it seems to me that the rate will continue to go up. So if you're waiting, if you're on the fence and a purchaser and you're thinking, should I buy, whether as a first-time home buyer or as an experienced home, property buyer, should I wait? I would say to you, if you find the right property for you, I wouldn't wait, because especially if you're seeking a mortgage, because the interest rate is only going to go up. The purchaser arranges for a home inspection. I don't want to belabor this, but it is very important to have a home inspection. Even if it's a commercial building, have a building inspection. A lot of people say, oh, I can save a little money there by not doing it. Well, you could. And then after closing, all of a sudden you find out that there's asbestos, or there are termites throughout, or there are faulty electrical wires and the whole system has to be redone. There's a reason to bring in a licensed home inspector, licensed by New York State in Albany. And that's because that person has experience, has knowledge, and can tell you where the pitfalls are. Sometimes the seller doesn't want to hear that you want a credit for something. I understand that. And as a seller, you may push back and say, I don't care what the home inspector says. But as a purchaser, making perhaps the biggest investment of your life, right? Homes in Bayville are very expensive, just like everywhere else in Nassau County. So shouldn't you know what the pitfalls are in your house? And if you decide, you know what, I see that the electrical wiring needs to be, or the plumbing system needs to be updated, then you know in advance. At least you're a little smarter about it. However, I would say to you, if there is a problem, major problem with a foundation or any kind of system in the house or in the building, the seller probably will negotiate. So I would definitely get a home inspector to come. The seller's attorney prepares the contract of sale. That happens every time because the seller is deemed to know the most about the property. The attorneys on both sides negotiate the terms of the contract. Do both sides need their own attorney, meaning not one attorney for both parties? Absolutely. Look, if I represent a purchaser, I'm looking to get the best deal for my client, not only price, but all of the protections. And if I'm representing the seller, I'm looking to protect my seller so the seller doesn't have to provide different resources, et cetera. So each side has its own interest. It is a conflict of interest for one attorney to represent both sides. Okay, we're going to keep going. The purchaser signs the contract first and provides a down payment check payable to the seller's attorney as escrowee. It's usually about 10% of the purchase price, but I see on a lot of these transactions where there's a bidding war, it's often more because that is a factor sellers take into consideration. The sellers sign the same contract of sale, and then you have a contract. Now, I want to say at this point, if you are a seller and you have accepted an offer from Zahava Schechter and have signed the contract. Remember, Zahava Schechter as purchaser has already signed and given your attorney the down payment check. And you've signed, you're the seller, and you've signed. You cannot then take an offer from Christie tomorrow. Christie's going to offer you more money. Too late. You've already signed and you are stuck with this contract, at least for, according to the terms of the contract, maybe 60 days, maybe longer. I'm not sure whatever your contract will say. So make sure when you sign the contract as a seller that that's really what you want to do. As a purchaser, you're also somewhat locked into the contract. If you decide you don't want to buy the house and you've given 10% of the purchase price on, let's say, a $500,000 house, that's $50,000, you can walk away as a purchaser, but you're going to lose your $50,000. And that hurts, right? So make sure before you sign, before you offer, that this is the house you want. Okay, the down payment goes into the attorney's escrow account. And then we get a title report. So I can tell you, title is ownership or lien search. I can tell you that Zahava Schechter owns the Brooklyn Bridge, right? But how do you know that? Until you actually look through the records. New York State has a land registry. Every county has the land registry. So Nassau County, 240 Old Country Road in Mineola, you can go and find out who owns any property in Nassau County. And that's the way it should be, because if Zahava Schechter is telling you she owns a property in Bayville and you do the research and she doesn't own it, why would you give her any money? So it's really important to see not only who owns a property, are there liens, are there judgments, whether from New York State, from the IRS, from a private creditor. It's very important to get a title report. Purchaser applies for a mortgage if applicable, otherwise it might be an all cash deal. Title objections are clear. What's an objection? So one objection might be, you know what, Zahava Schechter bought the house from Christie, but that deed was never recorded. So it doesn't look, when I say recorded, I mean filed, on file with the Nassau County Land Registry. So as a result, it doesn't look like Zahava Schechter owns it, rather Christie still owns it from a legal perspective. So that's just one title objection. There are many more. The mortgage company issues a mortgage commitment. Okay, I have to talk about this for a minute. A mortgage commitment does not mean as a purchaser that you're done. The commitment does not mean, okay, that's it. The bank is saying they're definitely going to fund my mortgage. No, 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 no. What they're saying is, based upon the documents you've given us, the W-2s and your tax returns and lots of documents, we think we're going to give you the commitment, but you need to keep updating the documents until we give you what's called clearance to close. And that is what you want. Clearance to close as a purchaser means schedule the closing. Okay, everybody's going to clear the file to close. The documents are prepared. And finally, you get to the closing. Seller gets their money. Really, that's all the seller cares about. The purchaser gets ownership of the property. The real estate brokers, if any, get paid. Happy ending, right? That's a good thing. I have to tell you, oftentimes, I would say when I do my estate work, the real estate work, the real property work is much nicer because generally speaking, a seller is happy to sell and get the money, right? The purchaser is happy to buy and have a home. Everybody gets paid, everyone's happy. So it's a nice area of law. All right, I want to talk about title insurance for a minute. Remember, I said to you, it's very important to find out who owns the property, if there are any liens, etc. The seller cannot require the purchaser to go to get title insurance from a specific title insurance company. So why is that important? It's important because if you have life insurance, for example, forget title insurance, life insurance, your company, your life insurance company owes the benefit to your beneficiaries, right? That's a direct contract you have with the life insurance company. The same is true for title insurance. When you go to a title insurance company, that contract is between you and the title insurance company. The seller should be nowhere involved. That is an obligation from the insurance company to you. So just keep that in mind. I've seen it numerous times in my 33 years of practice that a seller's attorney wants to steer the purchaser into a certain company. That's always a red flag. So don't let that happen to you. So who needs a lawyer at the closing? I saved legal fees and the seller threw in 7 liens for nothing. I thought this was great because actually the lawyers get the least amount of money of everybody. You know, when you look at realtors on the island normally get, I don't know, 4%, some get 6% of whatever the price is. That's tens of thousands of dollars usually. Whether they split it or not is another issue. A lawyer's fee is probably $2,000 or under, and that lawyer is working for you 50, 60, I don't know how many hours, because we need to protect you. It's not an issue for lawyers whether or not you purchase the property or you're able to sell, but we want to make sure you don't get into trouble and that everything is correct. The lawyer also helps protect you to make sure, whether as a purchaser, specifically for a purchaser, that there are no liens, there are no encumbrances, there are no problems on that property. Because if you're a purchaser and you're getting the seller's problems, I promise you, this will become your problem when you go to sell. Let's talk about marketable title versus insurable title. Marketable title is ownership that any purchaser will accept. Like Zahava Schechter owns property, but that's not insurable title. For example, I don't know how many of you have fences. Okay, a lot of times years ago, people would just put up a fence. I don't know if this applies to anyone out there. Didn't really matter, was it on the boundary line or not? There's something called adverse possession. If you're out of possession, meaning that fence cuts off your access to your land, your neighbor can now claim that land as his or her own, even though you've been paying taxes and you've been maintaining it and doing the landscaping, etc. You think it's yours, but it's really not. So there are issues that come up with fences, with all kinds of permits or certificates that are not in place. I have a transaction now with a house in Queens, which where the seller made a back room like a family room, and it's too close to the boundary line, and they can't get what's called a variance, an exception. It's too close. They're going to have to take down the room. That's not insurable. So just keep in mind that there are a lot of issues there, and that's what a lawyer's job is, to look out for you and make sure that everything is done well. New York State is an attorney-driven state in that we protect our clients, not the title insurance company, not the realtors. The realtor's job is to put the deal together and to make sure it goes to completion so they get paid, because they don't get paid unless you close. But the attorney's job is to protect the clients. They're not the same. Okay. So does it matter if a purchaser applies for a mortgage or if this is an all-cash deal? Yes, it does matter. I'll tell you why. First of all, if it's an all-cash deal, you don't have a bank looking over, you don't have extra fees. And generally speaking, if I have, I don't know, let's say you want $1 million for your house. I'm not going to, if I have all cash, I'm not going to offer you $1 million. Maybe I'll offer you 900,000. I'm not quite sure how much I'll offer you, but it's going to be less because you don't have to wait for me. Within 30 days, we're going to close. It's possible if I have to get a mortgage, I may not get approved. That's happened so many times in my practice. A purchaser goes and applies and isn't approved for whatever reason, usually because their income cannot justify, cannot satisfy the burden of the mortgage payment. But it does matter. An all-cash deal is, I think it's golden. I tell that to my sellers. If you can get an all-cash deal at a decent price, take it. Does the purchaser need a survey? Yes, for the reasons I just discussed, involving fences, back rooms, additions that were added on, decks that were added on without permission, right? Without a permit from the building department. Town of Oyster Bay has a building department. I'm not sure if the Village of Bayville does, but every town does. And you have to get their approval to make all of these changes to your property. What happens? So what happens when the property lacks the required permits and certificates? Did you know for your central, if you have central air conditioning, for that unit outside, I don't know if that's the compressor, but whatever that unit is outside, you need a permit and a certificate of compliance on it. If you have a shed, over, I believe it's 7 feet by 7 feet, you need a permit and a certificate on that too, or you can be cited and penalized for that. And again, we're talking, I mentioned below on my slide about the fence. More often than not, I see fences that are not on the property line. And there are ways we can get around that. We can put a gate on it so you can get through. But there are issues which, again, as a purchaser, if you don't deal with them when you purchase the property and let the seller off the hook, that will become your problem, when you go to sell. I found happiness in my own backyard, but my neighbor claims it's on his side of the property line. So, what do they say about neighbors? Fences make good neighbors, right? The best way to get along with your neighbor is to have a fence on the property line. because you don't want issues of this is my land versus no, it's not my land. I actually was sued. This is a true story. I was sued by my neighbor for land that my neighbor said was his. And I brought in my title insurance company, and they had to pay out money. So my neighbor received money, I received money. It was the title insurance company's fault, the surveyor's fault. But I have to tell you, it took about 2 years, and my neighbor doesn't talk to me anymore. So, you know, it's sad, but things happen. So make sure that that everything in your property is proper, and that you have the proper certificates as well. Okay, watch out for these mortgages on your property. So if you're a purchaser and or if you're a seller and you're going to purchase or sell, you have to pay off that mortgage, right? The mortgage otherwise will continue with the property. Most people don't think of it this way. They think I have a mortgage. No, 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 no. The mortgage is against the property. So if the seller doesn't satisfy, that's what is called satisfaction. If the seller doesn't satisfy the mortgage, it continues with the property. It runs with the land. So it must be satisfied. Liens, tax liens, mechanics liens. So like everything else, you cannot beat the IRS or New York State. If there are tax liens because the seller or a prior seller, right, a predecessor seller did not pay the tax liens, I can promise you that that continues to run with the land, and that must be satisfied. Mechanics liens. What's a mechanics lien? So you're a seller and your roof is leaking, and you have a contractor come in, a roofer, to fix your roof, but you don't pay the roofer. Well, what is the roofer going to do? Take down the new roof? No. The roofer will file with the from Nassau County a lien against your house, so that when there's any transfer of the property, that debt will be paid. Lis pendens. I have a case right now. Lis pendens means, and I'll explain to you, it means we're not sure who the owner is. We think party A says it's that person's. Party B says it's someone else. Party C says different people all claim ownership, and they're all saying, we want the court to decide, to judge who is the owner. I have one of those cases now. I must tell you, it's expensive. It's arduous, it's very long, and it's a pain in the neck. So just be sure that there's no question as to ownership, especially if you're a purchaser. Make sure your lawyer is clear that there is no problem in what's called the chain of title. A sold to B, who sold to C, who sold to D, and now D is going to sell to you as a purchaser. Make sure. Money judgments. So, you know, I've had these cases before where, I don't mean cases, I mean transactions, where let's say you didn't pay a doctor, you're a seller, and you went to a doctor's office and had an operation and didn't pay. The doctor then goes to a law firm and sues you and gets a judgment for not only what the fee is, right, what his or her medical fee is, but 9%, I'll repeat that again, 9% statutory interest. That's what New York State allows, plus lawyers' fees and all these other fees, and slaps it against the house. So you're going to ask me, how can that be? What is the money judgment? What does the operation have to do with the house? Well, if that's the only way, it can also be against a bank account, by the way, it can be against a lot of things. But if that's the only way that the creditor, the doctor, for example, in our example, can get paid, then that has to be paid off also. That debt has to be paid off. And as long as it's not paid off, it keeps running up interest, and it's going to just balloon. So if you're a seller and you have any of these problems that are on here, please take care of them before you list your property. Out of possession areas, we've already talked about that. Boundary line agreements basically mean, I don't know if you've ever heard this, but okay, you can keep your fence up, but you have to admit that it's my land. It's very problematic. Again, we run into the problem with our neighbors, getting along with our neighbors. I would say to you, if you're not sure if your fence is on the right property line, get a surveyor in. It costs maybe $500. I know that's easy for me to say, but at least then you know you're not going to lose your property, and you know where you stand to make sure that your fence is on the right line. Okay, I want to talk about some myths. And the reason I include this is because these are things that clients say to me. And I figure if clients say it to me, maybe those of you who are attending also have these questions. So myth number one, it doesn't matter if all the town certificates are in place before you sell. No, everything needs to be in place because the lender, the lender for the purchaser, right? The purchaser is going to go for a mortgage. So that bank, whatever that bank is, that's the lender, is going to look at this and say, look at the title report and look at the survey and look at everything and say, wait a minute, there's something wrong here. They have a second floor, but their survey from 60 years ago only says there's a first floor. There are no certificates in place for the second floor. And you know what's going to happen to you, seller? You're not going to be able to sell. Either that or you're going to have to put a lot of money into escrow. And maybe you're relying on that money to move to Florida or North Carolina, or wherever you're going, and you won't have that money. So take care of all this beforehand. I don't know if you've heard the term expediter. An expediter is someone who is familiar. Everything is local, right? If familiar with your town, with your village, with your town of Oyster Bay. There's some who are only familiar with Oyster Bay, some who are only familiar with town of Hempstead. So find the right expediter to help you to walk through that system and legalize anything that is not legal now. Here's another myth. Any side deal you make with the purchaser is enforceable. Oh my gosh, I got a call, I think it was a couple of years ago, maybe 2 years ago, from a buyer's attorney. I was the seller's attorney, a buyer's attorney. We're going to say that the price is, I'm making this up, I don't remember the exact amount, but $100,000 less because the money is coming in cash, whatever it's going to be, it's off the books. So we're going to put in the contract that, let's say it's a $500,000 house. We're going to say the purchase price is $400,000. And then at closing, we're going to give you $100,000 in cash. First of all, that's illegal. I got to tell you. So I shot that down right away. We went with other buyers, but that's not the point even. It's unenforceable. So even if you would agree to such an illegal scheme, you get to closing and the purchaser shows up with $400,000. And what can you do to get that 100,000? Nothing, because the contract of sale is what is enforceable. And it says 400,000, not 500. Side deals are empty. Or if they say, don't worry, we're going to leave that beautiful chandelier in the dining room. They don't have to leave it if it's not in the contract. If there's something you want, you're a purchaser and you want something that's there, or you're a seller and you want to take the chandelier with you, figure it out and put it in the contract. That's the only way that it will be enforceable. Oh my gosh, this can be for either side, the seller or the purchaser can sign a contract without reading or reviewing the contract with the attorney. Oh, I hear this all the time. I don't need to read it. So have it just tell me what it says. It's a lot of legalese and I don't really have the hour, which it takes the hour to sit with you and talk about it. So, why don't you just tell me and then I'm going to sign quickly and we'll be done. No, you must read any contract which will be enforceable against you. Why wouldn't you read the contract? Don't you want to know what could happen to you? And once you sign the contract, you can't say you were ignorant or you didn't have an opportunity. You're stuck with those terms. So it's very dangerous. And this isn't just a contract of sale. This is any contract which you would sign. Frankly, when I meet with clients to do estate planning and I listen to them, we meet numerous times, and then I prepare the will or I prepare the healthcare proxy or power of attorney, and they say, I'm not going to read, I'm just going to sign. I say to them, why wouldn't you read your documents? So I guess this is my way of encouraging you. Please read everything you're going to sign to make sure it's correct and that it really does meet your needs and that you understand what is involved. Okay. A signed contract of sale means the deal is done. That is not true. I just said to you before, just because you have a signed contract, if I'm the purchaser and Christy is the seller and she is expecting to move to Florida with the money for the $500,000 from the contract, and Zahava Schechter doesn't get a mortgage, I lose my job, I become sick, whatever the case is, I don't have the income anymore to justify the amount of the mortgage that I have requested from a lender, I'm not going to get the mortgage. and the deal is over. And not only will the deal be over because I don't get my mortgage, Christie's attorney is going to have to return to me my down payment. And there's nothing she can do. She can't sue me. She can't force me to continue. She can't keep my 10% down payment. So keep in mind, when you deal with someone, with a purchaser who has a mortgage, or if you're a purchaser who is getting a mortgage, that is a way out. That is a way out of the deal if you don't qualify. Purchasers need to prepare for the purchase only after the contract of sale is signed. No, please, purchasers, get all of your W-2s in line and your income tax returns. And if you got money from your parents, get a gift tax letter, and anything that the lender it could possibly ask you for, that your mortgage company could actually ask you for, have it all ready to go. Otherwise, you're going to be really far behind. It's going to take time for you to get that. So be prepared. That's the name of the game. There is some people say to me, oh, there's no difference between a condo and a cooperative unit. If you recall, I said at the beginning, there is a big difference. The cooperative unit, when you want to purchase it, or if you want to sell it, you have to get board approval. Condominium is not that case. You don't need board approval. So I do want to tell you one story. It's an old story, but it still unfortunately could happen now. So years ago, I do a lot of co-ops, but years ago, I was selling, or not selling, but I was representing an estate who was selling a co-op in Flushing. And if you're familiar with Flushing, it used to be a very Jewish area, and then it changed to, and my clients were Jewish, as am I, and it changed to an Asian area, just in that particular area. And what happened was the people who were on the board were from a certain Asian country. And the realtor was bringing, I don't want to say which country, it doesn't matter. And the realtor brought very qualified purchasers, prospective purchasers from other Asian countries. And the board, the first time, the second time, rejected the different purchasers. And so after the second rejection, I talked to the realtor and I said to the realtor, you've got to talk to the board and find out what they want. So she did. And this is illegal, by the way. All of this is illegal, what the board is doing, not what I'm doing, but what the board is doing. And once the board received an application from prospective purchasers who were qualified from the country that they wanted, all of a sudden, those purchasers were approved. Why do I tell you this? Because the board has immense power, the co-op board. If you ever purchase a co-op, you should run for the board because they determine everything. So a cooperative unit has a lot of issues. Also, the co-op board can tell you, you can't do this, you can do this. They basically run the roost. So just be aware there are a lot of control issues with co-op units. Okay. Here's another myth. Once the mortgage commitment is issued, the purchaser can close. No, not necessarily. I told you the commitment is not the be all and end all. You must get the clear to close. I have seen cases, transactions where the purchaser gets a mortgage commitment and then the bank says, no, we don't like the most recent documents we've seen. We're not funding. Very dangerous, very, very dangerous. Lender documents at closing are standard and do not need to be read. We already talked about the importance of reading before you sign. Many documents are Fannie Mae, Freddie Mac. They are standard, but not all. And some can be changed. Okay, let's talk about some COVID-related real estate issues. May a deceased person sell or purchase either real property, house, a building, condo, or personal property in the case of a co-op? No, only a person who is alive can purchase or sell. So what happens if you're in a contract with someone, and it doesn't have to be COVID related, but that seems to be happening quite a bit. What happens if that person dies, whether of COVID? Let's say you're the seller and the purchaser, or it could go the opposite way too, and the purchaser dies. So it's a personal contract. The deal is done. I actually had a case like this, but it wasn't COVID. Trying to think, about 2 months ago, person died of a heart attack. 2 days before we were supposed to close. Nothing could be done. The person died. You then have to go to the surrogate's court to apply for letters of administration or letters testamentary. That delays everything. But if someone on either side has died, the deal is off. Doesn't matter whether the property owner, decedent, the person who died, left a last will and testament, meaning died testate, or died without a will and testate. Of course it matters. It matters because if you die with a will, chances are it's going to be less expensive and faster for someone to get appointed so you could sell the property, right? As opposed to if you die without a will, it's more expensive. There are more documents, more legal fees. The courts take much longer to review. So it's always better to have a will. They say only 40% of American adults have any kind of estate planning. And those who don't pay for it, and often their wishes aren't honored because what happens is not what they would have wanted because they didn't leave a will. Here's some other issues. The Boy Girl Scouts were right. Be prepared. Have everything in place. So, for example, if the executor, if there's a will, or an administrator, if there's no will, is appointed, but there are no certificates, or if there's a trust and there's no backup trustee, then you have to wait until all these issues are resolved in order to sell the property. In the meanwhile, who is paying for the real estate taxes, the maintenance, if the roof leaks, fixing the roof, all of that? The seller has to pay, or if there's a violation, the seller has to pay for everything, any expense, up until the time that the seller conveys the property, sells the property. Which player in the real estate process is the defining player in how fast the process goes and closing occurs? So the players are the seller and the buyer. So a lot of people say, oh no, it must be the bank, the lender. No. Because if the seller and the buyer are prepared, everything is in order, there are no problems, it should go faster. So really, the lawyer can I can help only so much. I can prepare all the documents, but if you don't have everything in order, we're going to be waiting for you. The market is still hot, as I said, but how long will that last? I don't know. This is a great time, by the way, if you want to sell, it's a great time to list your property. People want to move probably by the summer because maybe they're changing school districts and they have school-age children. Hopefully they'll remain in school. And interest rates are inching up. So be aware, if you're a purchaser, you're probably going to be paying more for the same value property. So for example, if the property is worth $500,000, and that's what you're offering, but you're paying 4% as opposed to 3.5%, your monthly payments are going to be more expensive. What about the investment market? I don't know if we have any landlords out there. A lot of landlords are bailing. They're selling their properties. We had I'm trying to think of the word right now. There was a delay that there was no, you couldn't evict anyone. There was not an embargo, I can't think of the name, I'm sorry. But there wasn't the possibility of eviction for a long time during COVID. Now landlords can start to try to evict tenants who haven't paid for a long time, but it's very costly, and there's no guarantee that you can get a tenant out, even a tenant who's not paying rent so quickly, because if the tenant says he or she is sick and lost his job during COVID, whatever, it's going to delay everything. So keep that in mind too. I want to just say we're getting near the end of the presentation. I always try to talk, I speak to a lot of different libraries on different issues. I try to talk about unclaimed funds. If you're not familiar with this website, go take a look. I routinely look for lost money, unclaimed money for clients. You may find some for yourself, for your family members, for your friends, and it's great to find found money because New York State is holding on to billions of dollars. So good luck. And I want to thank you for your attention. I'll finish with 2 quotations by Benjamin Franklin. In this world, nothing can be said to be certain except death and taxes. I have recently husband and wife, new clients. The wife wanted, they both came to the consult, but the wife wanted to go ahead with her plans. And the husband said, no, you know what? I don't want to die. And like, this is all morbid thinking, which I do with the house, which I do, et cetera. So I'm not going to do anything. Well, if you're not prepared, whether with real estate or anything else in your legal affairs, your wishes are not going to be honored. By failing to prepare, you're preparing to fail. So I hope everyone is well. And thank you so much for your attention. And I'm going to stop my share. Here we go. And let's see who's in the chat. Will you be covering the taxes owed? This is Joe Tina. Hi, Joe Tina. Will you be covering the taxes owed by the seller after a sale? Okay, are we talking after a sale or at closing? Can you unmute, please? Thank you. Can you unmute?
Yes.
Okay, great. Hi.
I meant hi. I meant very nice presentation, by the way. Thank you.
Thank you.
I was wondering, yeah, this is my brother-in-law who has Parkinson's, and he sold his house in Montauk for quite a bit. He didn't pay a lot because he bought it 40 years ago, but he has no records of anything.
Ooh.
So how do you kind of decide how much you should claim against the house, against that sale, so you don't have to pay too much tax?
Okay, so this is Suffolk County. So we're going to talk about a couple of things. So first, thank you for your question. Every seller doesn't have a choice unless you are selling a new property. Then the buyer pays what's called the transfer taxes. I just wanted to talk about this for a moment. New York State has transfer taxes, and they are 4/1000ths of the purchase price. So if you take the purchase price and multiply that by 0.004, you'll find out what the transfer tax is. Seller can't get around that. Also, New York City, based upon the price, I just want to say, even though you're talking about Montauk,
Right.
Different localities have different additional taxes. So beyond New York State, New York City, you're either looking at 1% or 1.25%. Plus there are mansion taxes, Peconic Bay out in Suffolk County taxes, or all kinds of taxes. So, but I think what you're talking about is capital gains tax. And I'm so glad you brought this up because I want to talk about that.
Okay.
Every homeowner, right? You're on the deed. Every homeowner is allowed for their property to appreciate by 250,000 without tax consequences. If you are married, legally married, and if your spouse is also on the deed, then it's 500,000. But let's say you're married and it's from before the marriage, but you're selling it during the marriage, right? Your spouse is not on the deed. You still only get the 250. Okay, so what does that mean? Let's say, Joe Tina, I'm going to make this up because I don't know. Let's say the property in Montauk was purchased 50 years ago for 50,000. And let's say today it's sold for $1 million. Right. Okay. So
that's pretty close. I would say maybe 150, and it's sold for $1 million.
Okay, so we'll do $850,000 appreciation. That means increase in value. All right, so we already know, and if the owner is the only one on the deed, he can take 250. So we're left with $600,000 in our example, $600,000 in appreciated value, of which capital gains tax will be assessed. Capital gains tax could be assessed at 20%, 25, 30%. It's a lot of money. He's probably looking at a lot. So how do you reduce capital gains tax? You need to keep good records, which you say he doesn't have, and to show not that he painted, but that he put on solar panels. That's appreciation. Right. Show he put on a dormer, he put on the second floor, he put in a deck, he put in a pool. He did things to increase the value of his property more than just a paint job. Right. And then you can reduce the amount subject to capital gains. But if you don't have any of those, and if you go through all of his records and you can't find any of that, you're going to be paying capital gains tax. Now, I want to say one other thing. He purchased at 150. Let's say he died, and then the estate sold for $1 million. There is no capital gains tax because the moment you die, the IRS allows for what's called a step up in basis. So the fair market value whatever the sales price is becomes the cost basis price. I don't want to get too far in the weeds.
Yeah.
And there is none of this. The kicker is he has to die. So he didn't die and he sold it during his lifetime.
Right.
No way to get around capital gains tax. I want to say one other thing, just because you brought up such a great question. Thank you for that.
Okay.
Let's say, Joe Tina, you decide, I want to give my children the house. And you're not, and a lot of people ask me this, I just want to give them, or I want to put their name also on the deed. I'm not taking any money. That's called no consideration. Consideration is not, you're being thoughtful. It means there's no exchange, there's no money. That's not always a good idea, because then your children or whomever to whom you're transferring the property get the same 150,000, so that when you die, they don't get that step up in basis. Their cost basis is still what yours was, the 150. So be careful. I want to share with you one other thing. I'm sorry, I'm going off tangent. I met with a prospective new client. I don't know if she's going to retain me, but I met her last week. This is what happened. She refinanced her. She was a mature woman. Her son, who's an adult, was trying to help her. And she refinanced her house in Elmont, which is Nassau County. And she, because of her age and her financial financial status, was able to get a special senior enhanced exemption. And she was saving $5,000 a year, which is substantial, $5,000 a year in taxes. They refinanced in November through a local bank, doesn't matter. And the son said to the mortgage banker, while we're there, didn't have an attorney, while we're there, let's put my name on the deed. And they did. And what happened was Nassau County said, you, son, are not 65 or older. Therefore, mom loses her $5,000 exemption. So my point here is all these conveyances and sales are complex. And just be sure you know what you're doing before you do it. I don't see, Joe Tina, how your family member is going to get away without capital gains tax. So whoever the attorney is who did the closing should have prepared what's called a closing statement with supporting documents. You take that entire packet and you give it to the CPA and hope the CPA can figure it out.
Yeah. Well, I suppose, you can't deduct, he's had the house for 40 years. Maintaining the house, $5,000 a year, you can't do something like that, nothing.
No, it has to be what's called a capital improvement. Something that, in fact, I think that was one of the slides, making a significant alteration to your house, a new bathroom, a new bedroom, No, maintaining the house is not there. Sorry, but I would give everything, the packet, to an accountant. Hopefully the accountant can figure something out. Thank you very much for your question. Paula, would you recommend accepting a binder when you're selling your home? No. Why would you accept a binder? I'll tell you why. Paula, I don't know if you hear me. Anytime you accept something, you're kind of on the hook. Why do you want to be on the hook for any buyer? So I want to share with you a story, which is, and I represent sellers and buyers, right? So the seller is getting different offers, some high, some low, whatever. So I've had clients say to me, send out contracts to everybody, anybody who's offering, and see who is the first buyer to actually sign and put their money where their mouth is, give you a check, right, for your escrow account. And I've done that. There's no problem. That's totally legal. If you accept a binder, that means you're holding that property for that buyer. That buyer can wait and wait. I don't know what the terms of the binder are, but give yourself the maximum leeway to either pick another buyer or get a higher price. Again, you, Paula, you as seller are only obligated once you sign a contract of sale. But if you're going to sign a binder ahead of time and you're not going to be able to show the property to somebody else, what a shame. So no, I don't recommend it. And you know what? You know who pushes binders? I don't know if we have any realtors on here. Realtors push them because they want to make sure they've got you. I don't push binders, no. Moratorium, thanks, Todd. Yeah, that's the word. Thank you. There was a moratorium on evictions. Thank you so much, but that has been lifted. Do you still have 2 years to purchase a new house after selling your old house without tax consequences? So Skip, we're coming back to the $250,000 exemption. So the idea being, if you sell your house, right, and then you move to another house and you live in that second house for at least 2 out of 5 years, right? So you have lived in the second house for 2 out of 5 years, you get the 250 exemption again. I hope that answered your question, Skip. Okay. And that's all I have. Anybody else has a question?
Hi, this is Paula. Thank you for answering the question about binders. That's exactly what I was hoping to hear, but I do have another question. On one of the slides, you talked about when your buyer doesn't get a mortgage. Is there a way as a seller to protect yourself from that?
When you say protect, you mean so that your property is not off the market for at least 2 months, and then you have to relist it. You're like back to square one. Is that what you, no. The
No.
only way to protect yourself, Paula, is to take an all cash deal. And then it's a 30-day sale and that's it. They can't get out. You're done. No,
Is
but with a mortgage, if I'm the purchaser and Zahava Schechter gives you the letter saying Zahava does not from I'm making up from Chase, or from any credit union, whatever, and saying Zahava does not qualify for the loan, your attorney has to give me back my down payment, and you're back to square one.
So you just have to hope that doesn't happen.
Well, it's interesting because I want to talk about pre-qualification for a
Okay.
moment, because a lot of times people, especially realtors, will say, oh, the buyer is pre-qualified. And this, for buyers, you should know this too. Buyer is pre-qualified. What does that mean exactly? What that means is I'm the buyer. I go to Jovia Credit Union and I say to them, this is my income. This is what I have in assets, et cetera. They don't look at any documents. They're not verifying anything. And they say, okay, if everything, we're going to presume everything you're telling us is true. Based on that information, sure, you would qualify for a loan. That means nothing. So pre-qualification is really unhelpful. What I tell clients is, can you get something else? Can you look at clients who are sellers? Can you get a bank statement? Now, that doesn't mean that, and not every buyer wants to show you a bank statement, but that doesn't mean that the next day they won't, withdraw the money from the account. But at least you see that they have some assets, right? But even so, even if they qualify right now, if 2 months down the road, they get a letter from a licensed, lending institution saying Zahava doesn't qualify, you're going to be back to square one, and you cannot keep my my down payment either. I'm sorry.
Good, thank you.
Okay. Is pre-qualified different from pre-approved? No. No, you see, the problem, Todd, is that the bank is not looking at any documents. They're taking Zahava Schechter's word. So it means nothing. Don't rely on that. Okay, anything else? One other thing, if there are any first-time home buyers here, based on your income level, you might qualify for Nassau County First-Time Home Buyers Grant. And I don't know if there are other programs available in Bayville or in town of Oyster Bay, but there is a Nassau County First-Time Home Buyers Grant, which from time to time is available. So if you are a first-time home buyer only, I would definitely look into that. Okay, Christy, I don't see, how long does it take to close? Oh, what a great question. Todd, can you unmute for a second?
Yes, how you doing?
Hi, Todd. So in what kind of situation where there's a mortgage?
Yeah, so I'm selling my property and, I was just wondering how, I know I have to maintain the mortgage and the house and everything. And I was just, say it is a mortgage deal. I think that's what most of the deals are. How long does it generally take?
Okay, are you in contract? Are you already in contract?
No, I'm just putting it on the market next month.
You're just putting it on the market. So would you consider an all cash deal?
Sure.
Okay, so if you get, again, it might be a little bit lower offer, but then it's 30 days. If you get a mortgage, one of the issues, Todd, I would say to you when you're looking at offers is how much are the purchasers offering as a down payment. For example, if they offer, let's say the house is worth 500,000 and they're offering $25,000, buyer one, but
Mhm.
buyer two offers 50,000 or 75,000 or whatever, some higher amount. That's something to consider too, because that means chances are it's more serious. So how long will it take? So if it's a house, I would say 60 days. Could be less, could be more. If it's a co-op, probably double that. But hopefully within 60 days.
Okay.
Could it be longer? Yes, anything could be longer. You know, in the height of COVID, when people were not in their offices and title companies couldn't get into the county offices, things were taking much longer, but pretty much people are back in the office or at least have access. So I would say 60 days is reasonable.
And do you have a general idea how much it costs to close for the seller?
Okay, so what are the seller's costs? Good question. First of all, you have your attorney's fee, whatever that is. And by the way, every attorney should give you, whoever you go to, should have a retainer agreement for you to review and sign. It says what your obligations are and what the attorney's obligations are and any fees involved. So you definitely have, if you live in Bayville, you definitely have the 4/1000 transfer tax, right? Whatever the
Mhm.
price is, the selling price times 0.004. That you know you definitely have. If you need to pay off a mortgage, let's say you have a mortgage, do you have that?
No, it's free and clear.
Very good. Okay, because if you had a mortgage, then there are all kinds of pickup fees, etc. The only thing I would say, so I think all you're going to have, if there are no liens and no mortgages and nothing, I think you're just going to have the attorney's fee, whatever that is. I'm sorry. Do you have a realtor?
Yeah, I have a realtor.
You have to pay the realtor's fee, right? So that would be a
Yeah.
cost. And
It's like 4%.
right, I would say 4% is the going rate on Long Island. Whether it's split between the listing agent, who is your agent, as well as the buyer's agent. Actually, you know, I'm going to interrupt for a second. We'll come back to cost. Actually, both of those agents belong to you. I don't know if you know that, unless a selling agent, meaning one who represents a buyer, signs with the buyer a separate buyer's broker agreement, even the buyer's agent is beholden to you to get the best price for you. So keep that in mind when you go. But anyway, what other fees? So you have the transfer tax, you have the broker's fee, and okay, so there's something called a gratuity for the closer. There will be a closer who comes to the table. Usually, especially if you don't have any pickups, it's probably $100. If there would be a pickup for a mortgage, it might be $250 or whatever. But so I think that's it, basically, those three costs. Good luck to you.
Great, thank you.
Sure. Can you subtract a repaid loan on the house before figuring capital gains? I don't understand what that means. Jotina.
You were just talking about those closing fees. Do they come off?
Well,
the
the closing fee in terms of the transfer tax, but your family member, was it a brother-in-law? I don't
brother-in-law,
remember.
yes.
Yeah, your brother-in-law didn't pay that because the seller pays that. So
Oh.
it's got to be something that he paid.
Okay, so he did the realtor and that.
And he didn't pay the realtor. No, the seller pays the realtor. So those aren't fees that the buyer pays. What does the buyer pay? Wait, what does the buyer pay? The buyer pays title insurance. He can add the title insurance. That might be.
No,
I
he's
don't know.
the seller. He's the seller.
No, but he can add that to his cost basis. So if he paid $150,000 and it cost him $2,000 years ago for title insurance, so now his cost base is up to $152.
Okay,
Right? That's a buyer's fee.
okay.
I hope
But
that
the
helps.
sellers, no seller's fee.
No, only what you as a buyer paid at the time you were a buyer,
Yeah.
can you now add basically as a seller. Yeah.
Okay.
Sorry about that.
Okay,
Anybody else? Last call. Okay, Christy, I think we're done.
thank you again.
Thank
Thanks.
you, everyone. Be well.
Yes,
Okay.
thanks, Zahava. If anyone missed any part of this, it will be available on YouTube on our website. So if you just go to Bayville Free Library website, you'll see the YouTube link and you can click on that and you'll be able to watch this program.
Thank you, everyone. Good night. Thanks.
Everyone,
Thanks,
have a good
Zahava.
night.
Bye-bye.